Good morning. We've already formed a quorum and it's time for us to start. So please invite the officials to come in.
On
the 31st of March, this committee received a letter from Dr. Priscilla Leung, which indicates her intention to withdraw from the subcommittee. She has not stated the reason. Good morning. Ms. Chung, you have some answers for us in relation to questions raised last time. Yes, Mr. Chairman. We don't have a paper. Last night, I communicated with your Secretariat. I'll use the Secretariat's preliminary checklist on what we have to follow up. Is this appropriate? Yes. Number 1, that is A. We went back to see whether we should add in a definition on original document to clearly explain under Rule 13 boy. This will not be an original document, so we'll handle it that way. We believe that this impact will not just be on Part 5, because original document will impact on other documents. So we'll add in a new definition, so no problem for that. Number 2, last time members would like to have a definition on intervener, 介入者, to clearly explain that there can be 2 categories of persons. First of all, the Competition Commission and persons with a due interest. No problem for that. We'll add in that new definition. And then for 13 bracket A, 8. This is rather technical. Maybe I should refer you to 13.8. 13.8. Previously, we had a paper on this. If a litigant needs a substitute service, that is a substitute service, 替代送達. Last time, your legal advisor suggested that we should further clarify this. An application should be lodged first, and an affidavit must accompany that. We agree to that, so we'll amend 13 bracket 8. You go to the registrar for such applications, right? I think I have to go back and check. In law, there's flexibility. It's talking about tribunal. Apparently, a judge can do that, not the registrar alone. But usually, the person will apply to the registrar. May I defer to the DOJ? Colleagues of the DOJ? Yes, usually they'll go to the registrar first. It's only when a major issue is involved that they'll go to the judge. Maybe in the code you should include this as well. Number 4, Rule 20. Rule 20 is about intervention by third party other than Commission. That is page 30 of the schedule. We're asked to refer to overseas experience. For example, in 20(1), there's this term of a person with sufficient interest. Last time, members asked us to go back and look at overseas laws to see whether there's a more detailed definition on sufficient interest and whether in overseas jurisdictions there are precedents to explain what sufficient interest means. By sufficient interest, well, we've actually referred to 3 jurisdictions, Australia, the UK, and so forth. And we noted that for the same expression, sufficient interest, is found in UK's Competition Tribunal Rule. In that rule, in Rule 16, the same term is used. Chairman, there's only an English version.
Sufficient interest in the outcome may make a request to the tribunal for permission to intervene in the proceedings. 而喺個法例上面呢，佢哋係並沒有係並。
In law, they don't have a more detailed definition or explanation on sufficient interest. The DOJ helped us go through the case law, and for the time being, we've not found any precedent. The only case we found is that when the UK legislated on this, in the House of Lords, their officials cited examples on persons with sufficient interest. Consumer Association and Trade Association were mentioned then. Members asked last time whether a consumer can also be considered as a person with sufficient interest. Last time we already said that we would not rule out that possibility. And after referring to UK information, we do not intend to exclude consumers. In overseas jurisdictions, they don't have any further elaboration on the definition of a person with sufficient interest. Our view is that we have to look at the facts as well as the laws. It is rather difficult to write in all the details in the law. Judges did refer to the facts of individual cases, the prevailing circumstances. The status of the person is not that important, whether it's a consumer or a company. The most important point is to state the interest itself. So we're still of the view that Rule 20(1) is sufficient as it now stands. I don't know whether members find this all right. Mr. Andrew Leung. Well, first of all, I have to declare that I'm a member of the Competition Commission. Well, you mentioned the case law for people with sufficient interest. Last time, our colleagues raised the example of consumers. If I buy in a supermarket, am I a person with sufficient interest? But in case law, the intervention of the consumers, for example, the Consumer Council, in our case, should that be considered as a person with sufficient interest? If I buy something expensive, a lot of people may be able to intervene. And just now, the government cited the example of the consumer group or the trade associations. Therefore, although I agree that each case is different, whether or not we should legislate on this definition and whether we should clarify the legislative intent, I think we should discuss, because if everybody claims an interest and intervene, there may be trouble.
比較即係純粹係字眼嘅。事實上，你 intervene 咁。
Of course, you have to represent yourself, or you can find a lawyer, but there is a cost involved. So we need to be careful that we do not result in the fact that people related to but who don't have a sufficient interest, is involved. There's no clear definition there now, so we need to be careful with this. I feel that, of course, if there is sufficient interest, there should be intervention, but we should not allow that because there's no definition for sufficient interest. It'll be difficult for the judge to make a judgment. What is it? What do you mean by sufficient interest? The legislative intent, what is it? I think we need to make it clearer. Ms. Zhang, I think, let me supplement. Sufficient interest, according to Hong Kong law, is covered extensively. Let me read you some laws. For example, the High Court Law Chapter 4, Section 21K, regarding to judicial review, rules of High Court. There's also cover of sufficient interest in the Mental Health Ordinance, even Competition Ordinance and Companies Ordinance mention of it too. All these laws actually refer to this term. In the High Court rules in relation to judicial review, room is reserved for various scenarios. So it may not be appropriate to stipulate in the law, the precise definition of sufficient interest. But if members think it's advantageous to do so, we can come up with some, practical guidelines. That is, detailed explanations provided by the court to help the parties concerned understand what is the interpretation. So we can consider actually coming up with this sort of guidelines. But that's whether there's a need for sufficient rationale to justify intervention. Yeah, can you do that in the form by way of guidelines? Because for sufficient interest, when it comes to judicial review, that, of course, judicial review is an important cornerstone of Hong Kong. People do resort to it. And so we should be mindful of any possible gaps in the law. That is, people, would really use the legal aid and resources appropriately. We need to deal with it carefully. We need to strike a balance. I think in your practical guidelines, you can actually make it clearer. Thank you. Thank you for your reminder. We'll try to strike a balance in our future wording. Please continue. Okay. We talk about E, whether we should make Rules 21 make it clearer to delineate the meaning of sufficient interest. Later on is on Rules 22. It refers to Annex A, page 14. There are members who mentioned that there are some situations where the plaintiff may be substituted. Members then thought, under what circumstances would this happen? Would the substitution happen? Well, maybe I asked the DOJ to provide the relevant information. As for Rules 22, point 1 says without affecting Rules 20 and 21. In Rules 2021, there are two scenarios. So Rule 22 has to list out and specify that Rules 20 and 21 will not be affected. And in subsection 1, it's mentioned that the tribunal may permit another person to be joined in the proceedings or in substitution of any party. And this will clarify the provisions because it spells out the power of the tribunal to allow more people to join in the proceedings or substitute any party to the proceedings. Last time, we studied the example, the scenarios under which such application can be made, an application for substitution of any party to the proceedings. Like, for example, someone who's passed away or someone who has gone bankrupt. Then there could be applications made to replace the original party to a proceeding. So the provision here has also the purpose of accommodating such scenarios, and the tribunal, in such circumstance, may allow for substitution of any party to the proceedings. And in subsection 2, it says that Order 15 of the RHC applies to any proceedings. So when the court, decides on where to permit someone to join the proceedings or to have an substitution, this Order 15 actually includes detailed guidelines in relation to the application. So for subsection 2, yes, reference is made to Order 15. So that if there's anyone who wants to, based on Rule 22, make an application for substitution or to get another person to join the proceedings, they can make reference to Order 15 of the RHC. Okay, it's clear. Please continue. Thank you, Chairman. Okay, now there are 4 other items raised last time related to Rules 30, right of audience. For the first concerns, members request that whether we can provide, how a similar rule, like similar to Rule 30, is used in other courts, and whether we can make this rule clearer so that lawyers overseas can, through ad hoc admission, want to deal with, cases related to the competition law. And thirdly, you asked us to consider whether the ad hoc admissions applications can be referred to the tribunal, the judges in the tribunal. That is, it can be decided upon by the judges in the tribunal. And the fourth recommendation by members is that under subsection 1B, Roman 2 in the rule, that is, any other person allowed with the leave of the tribunal to appear on the party's behalf, whether we can make it clearer that this refers to persons who are not lawyers. So let me deal with these 4 items one by one. As for the ad hoc admissions, that is admissions by overseas lawyers who wants to, take up one particular case in Hong Kong. Let me just talk to you about the arrangement in the High Court. In the High Court, the usual practice is these applications will not be dealt with by the judges in the court of first instance. Rather, it will be dealt with by the High Court. So on the basis of members' recommendations, I discussed this issue with the judge of the High Court. They asked us why they would not ask the court in the judge in the CFI to deal with it. It's because they are concerned about the issue of perception. Because in dealing with such applications, the judge will need to listen to the views of the applicants, DFJ, and also the Bar Association, and to see what views or what arguments they may have, or why there isn't this professional in Hong Kong that can deal with the case, why someone overseas has to be used. but they wouldn't listen to the views of the other party. So the judge in the High Court holds the view that if we ask the presiding judge in the CFI to handle the applications, then this will lead to the impression that this judge may enter into a unilateral communication with the applicant, and this is something that we must avoid in our judicial system. So that's the main consideration. Secondly, according to the experience of the High Court judge, dealing with these applications, of course, the main consideration would be its implications on public policy or matters with public interest. So this High Court judge tells us that based on his experience, you do need to have experienced judge and judges who do not need to be very familiar with the relevant law to deal with such applications. So I was told that, of course, court of first instance deal with a lot of complicated laws, and competition law is also very complicated. But the judge I consulted said that there are a lot of competition law in the civil arena as well. But so they would tend to actually pay attention to the impact on public policy. So actually, whether it's for the CFI or either courts, if there's a need to bring in an overseas lawyer, mainly this application will be dealt with by the senior judge of the High Court. Therefore, based on the previous considerations, particularly in relation to the issue of perception, the High Court judge would not recommend making an exception for the Competition Tribunal. So I'd like to, I heard from the legal profession that in dealing with such, issue of right of audience, some members of the legal profession are worried that where the system could be abused, particularly for some cases where the cases may not be that complicated, and yet the court, might actually allow overseas lawyers to take over the case. So I'm just suggesting you mentioned about the senior judge in the High Court, right? Who you consulted. Yes, Mr. Zheng. That's the judge, Mr. Zheng, that I consulted. Okay, and further on, Rule 30 for ad hoc admissions is not something to be regulated by the law. Instead, it is regulated by the Legal Petitioners Ordinance, Chapter 159. Section 27(4) of that chapter spells out the power given to the Court of First Instance to deal with the applications. The Legal Petitioners Ordinance is actually applicable to courts, whether it be the High Court, CFI, or the future Competition Tribunal. So lawyers involved in cases handled by those courts are governed by this ordinance. The Bar Association has discussed this with us, and in discussing with them the rules for the tribunal, we've told them that we can just list very clearly that under Rule 30, overseas lawyers would not be subject to preferential or different treatment. They would remain governed by the Legal Petitioners Ordinance and the ad hoc admissions requirements. And the Bar Association thinks that's enough because all existing provisions related to right of audience would not actually have additional provision. So in our discussions, we agree that we also agreed on what we should put into the legal practice guidelines. So we're just talking about a general requirement here, and nothing special prepared or dedicated to the tribunal, commissioned by tribunal itself. So we would not recommend actually writing it in a different way. So, and the Bar Association understands very well that there's no so-called shortcut.
Let me refer to the 4 issues that I just mentioned. Apparently, we've already met those requests. So in the code, we'll set out more details, such that laws related to the Competition Tribunal will be similar to those for the Lands Tribunal, and so forth. So for Rule 30, you spell out the details in the rule of practice. In fact, the bar has already written on that. We'll go back and see whether we can include more details. And then we'll further communicate with the Bar Association. Their stance is clear. Ad hoc submission will be required. So you further discuss with the bar. Yes, we'll consult them on the rules as well as the rules of practice. We'll consult all the stakeholders. Yes, point understood. Last time we also discussed Rule 40. Rule 40 is about frivolous or vexatious proceedings. Last time your legal advisor asked us about the High Court rules in relation to Order 32A, whether or not it is necessary to amend Rule 40 to introduce Rule 32A of the High Court rules. Last time your legal advisor raised the point that the High Court Rule 32A order is different from Rule 40 here, because in that order, the CFI allows that person to be known as a frivolous or vexatious litigant. Such a person, if he comes forward for another legal proceeding, will need to seek leave from the court. In the High Court Ordinance, Chapter 4, Section 27, there is an empowering provision stating that the CFI does have the power to make that order, to add such a requirement for court permission for a frivolous or vexatious litigant. So we have to consult with the High Court judge, because this court permission is a special power. The Commission Tribunal is just a technical court, and we don't have a principal ordinance to govern the tribunal. So it is not appropriate to amend 40 to delegate that power to the tribunal. For a frivolous or vexatious litigant, we really have to go back to the CFI to see whether another arrangement should be made for that frivolous or vexatious litigant. Point taken. And then for Rule 44, last time for Rule 2G, we have this unless order. Well, mainly your legal advisor said that for the unless order, it is frequently used by the CFI. That is, by a certain date, if you don't do something, you'll be punished. And we've got a list on that. Your legal advisor said that for the unrepresented litigants, in order that an ordinary member of the public understands this better, we should have a clearer definition on what an unless order means. Originally, we did not quite agree to that viewpoint because an unless order is very frequently used by the court, and the CFI does use this very frequently and commonly. But we don't oppose to a clearer definition on an unless order. Point noted. So much for points raised at the last meeting. If members don't have further questions, we'll go back to Competition Tribunal Rules. Rule 46. If I remember correctly, last time we stopped there. Yes, thank you, Mr. Chairman. We'll continue with clause-by-clause scrutiny. As the Chairman said, last time we stopped at Rule 46, interpretation of Division 9. It's page 31 of the English version. Can I start? Yes, please. Rule 46 is about the interpretation of Division 9. Is only on transfer order, right? Rule 47 stipulates that the tribunal can make a transfer order to transfer proceedings to the CFI. Rule 48 specifies that after a transfer order is made by the tribunal, the registrar must, as soon as practicable, send the relevant instruments to the High Court. Rule 49 specifies that the transfer order itself would not affect the right of appeal. Legal advisor, there's an English drafting issue here. For 49(1), it says that the tribunal may make further directions. In other pieces of legislation, as in 99(3), a different expression is used. We'd like to thank the legal advisor for the comment. We'll go back and consider internal consistency. Next, Division 10, Rule 50. Rule 50 stipulates the power to adjust time with something similar for the High Court. And then Rule 51 is about sittings and days on which the tribunal opens. Any specific period, there will be a special arrangement. When we visited other jurisdictions, we discovered that very often this involves emergency cases which have to be processed quickly. So the tribunal won't have a period of rest such that it can handle cases, emergency cases, anytime. Rule 52 proof of decisions, block exemption orders, and commitments, etc., which can be adopted as evidence so as to streamline proceedings. And then Rule 53 is to allow one official language or both official languages to be used in any proceedings. This is very similar to the ordinary arrangements in courts. Rule 54 says that if a litigant is not conversant with an official language, then maybe a translation of the document in another official language may have to be provided. This is also similar to the practice in the High Court. Rule 55 includes documents that can be filed and inspected. For example, affidavits. In the Competition Tribunal, documents with commercial secrets, for example, may have to be handled. So, a special leave or permission from the court is necessary. Rule 56 specifies what documents can be inspected by persons. As in other cases, tribunal leave is required. Well, for 55(4) is the party may search. So does that also mean a party in proceedings or a party to any proceedings? well, the word party is defined in Rule 2. That is either party to the proceedings. That is, the person inspecting a copy of a document can, within normal office hours, inspect those documents. What about a party in 51? You also adopt the definition in Rule 2, right? Including the intervener and the interested party, right? Yes. All right, please continue. Then we move on to Rule 57 in relation to amendment to documents filed. All amendments have to be approved by the tribunal. And then 58, clerical mistakes and slips can be corrected. This is similar to the arrangement in the High Court. I recall that when we scrutinized the Administration of Justice Bill last year, we once raised the point that the district court judgment should be uploaded onto the website. And later, the Secretary for Justice agreed to write that into the law, such that more Hong Kong people will be able to read the judgments. That is to enhance transparency. For Rule 56, right of persons to inspect documents. Can the judiciary confirm that in future all judgments would be made public and uploaded onto the website? Will this arrangement remain unchanged? Yes, Mr. Chairman, I can confirm that for district court and above, all judgments will be uploaded onto the website. It's just like what we do for the High Court. But for this tribunal, there may be commercially sensitive information which may have to be covered before uploading. So any single party can make such an application under 62, right? I believe in the rule of practice you spell out the details. Well, we'll see whether more details should be included. All right, we just finished 58. Yes, if members have no further comments, we can continue to Part 3. We can move on to Part 3. These are special rules to handle review of reviewable determinations. First of all, Rule 59, which is about the interpretation of Part 3. All right. Rule 60, about application for leave and the proceedings required. First of all, a notice in Form 7 has to be served and filed, and the proceedings thereafter.
And then is Rule 61. The tribunal can, without a hearing, determine an application for leave. But if the tribunal sees a need for a hearing or the applicant requires or requests for it, then such hearing has to be arranged. Member? Okay, what criteria would you use to decide whether a hearing should be held or not? Thank you, Member. I think the judge would judge on the basis of the proposal and consider whether he's got the views of one party and whether he wants to listen to other views as well. if there's a need to listen to views of both sides and see whether a hearing should be held. Normally, we would deal with the application in writing first, so we need to consider various factors indeed. So it's up to the court to decide whether there's a need for the hearing. So it's similar to the application for judicial review. It's up to the judge to decide, whether it's justified. If the judge thinks that the hearing will be reviewed, the review will be approved, and there will not be a need for hearing. So, but if the judge thinks that there's a need for gathering more evidence and views, then he will call a hearing. Yes. Okay, section Rule 62. It stipulates that if the tribunal grants leave to make an application for a review of the reviewable determination, it may specify the grounds in respect of which leave is granted. And impose terms that the tribunal thinks fit. And Rule 63 stipulates that if the tribunal refuses to grant leave to make an application for review, then the applicant may appeal to the Court of Appeal. Rule 64, the applicant of an application for leave must, within 7 days, serve on the respondent and the interested parties. And also, the next rule states that the respondent must, within 28 days after the day on which the documents are served, file a response. 66 covers the provision for failure to file a response. 67 covers the affidavit in reply. Section 68 stipulates that, except with the leave of the tribunal, the after an affidavit implies file, or after the intermediate period is expired, the parties must not file or serve any further documents. Rule 69 talks about the withdrawal of application, and Rule 70 covers the state of execution of reviewable determination. Rule 71. An application to refer a question of law to the Court of Appeal must be made by filing a summons. For Section 71(1), it would state out, what sort of legal viewpoint that he wants the Court of Appeal to address. Yes. Under 86 of the ordinance, it stipulates the procedures involved. We actually now include Section 1 or Rule 71(1) to actually get the court to state the legal viewpoints. Legal advisor. On 70 and 71, I noticed that for the applications covered by these two rules, the summons must be in English. It says that there's a provision for the filing of summons. But can the administration clarify, when an application is made, what will the procedures involve? Why did I ask this? Because members can recall that for the rules of the Competition Tribunal, there'll be forms used to help people launch legal proceedings in a convenient way. And so there's also provisions on, applicants, trying to make applications by filling in the form. So this section 71 and 71, the summons mentioned here, they refer to the forms enclosed here. So if they're the same, then can we make it simpler, using the word forms? or specifying that forms can be used, filing a summons. Indeed, there are other provisions that mention the filing of summons as well. So if the administration thinks that we allow people to use forms instead in making an application, then should we make it consistent throughout the rules? Yes, let me supplement here. Yes, as for Rule 8 in Annex A, we did stipulate that for all forms must be used for all applications, and it applies to all the provisions. And I think that section already does away with the need to repeat it again in other sections. This is made with reference to the practice by the Lands Tribunal. Section 17A of the relevant ordinance. So it means that we don't need to repeat the same wordings in individual provision. I think about 10 situations or provisions where these wordings are used. So we think that Rule 8 would be sufficient, to actually convey the idea that people can apply by filling in the forms. Let me supplement. If you look at Rule 8, it says that all interlocutory applications to the tribunal must be made by filing a summons in Form 2 in the schedule. So Ms. Jones said that this actually covers other sections too. But we can note that for the sake of convenience to users or make it user-friendly, sometimes if we can actually make it easy to understand or clear in each provision, then that will make the rules more user-friendly. And the rule also mentioned in Section 8 or Rule 8 covers interlocutory applications. So the applicants must be able to distinguish between interlocutory applications and non-interlocutory applications. So and only then can the applicants know the difference between, if there's any difference there between Rule 8 and Rule 71. Yes, I agree. But in that's the case, we try to make the provisions more simple, but we'll look at it again and see what we can do. I'll discuss it with the judge again, based on your suggestion. Okay, if members have no other questions, let's go to Rule 72. Page 38 in Annex A. This is a section on applications for enforcement before a tribunal. Rule 72 covers interpretation of Part 4. Rule 73 covers application of Division 2. Okay. Rule 74 covers mode of application, that is Form 1, and the information needed. Yes. Rule 75 provides that a respondent who served with an original notice of application must, within 28 days after the day on which the document is served, file a response and serve a copy of the response on the applicant. And Rule 76 states that if the respondent fails to file a response within the time specified, then the applicant may apply to the tribunal for an order granting the relief sought in the application against the respondent. Rule 77, the applicant may, within 28 days after the day on which the response is served, file a reply to the response and serve a copy of the reply on the respondent. And Rule 78, after the original notice of application is filed, the tribunal may, from time to time, and in addition to its power exercisable under Rules 25 and 27, give any directions about the further conduct of the application, including the filing of the affidavit, any witness statements, and so forth. 79 stipulates that the applicant may at any time withdraw the application file under Rule 74 with the leave of the tribunal. 80 provides that Application for extension of time under Section 94(3) or 99(3) of the Ordinance must be made ex parte and supported by an affidavit. Rule 81. An application for an interim order or its extension under Section 95 of the Ordinance must be made by filing. Rule 82 covers application for disqualification order. 82 states that a disqualification application made together with an enforcement application has to be made in accordance with Division 2 of this part. If it's made as a separate application, then it has to be made in accordance with this division. So different procedures here. Rule 83 covers application for disqualification order. A disqualification application must be made by filing an original notice of application, and also the applicant must serve on the respondent a copy of the original notice of application. 84. An applicant for leave of the tribunal to participate in the affairs of a company must be made by filing a summons, and the applicant must serve on the commission a copy of the summons. And 85. The respondent who is served with an original notice of application or summons must, within 28 days after the day on which the documents are served, file an affidavit in opposition and serve a copy of the affidavit on the applicant. 86. If the respondent fails to file an affidavit in opposition within the time that is specified, that is within 28 days, the applicant may apply for an order granting the relief sought in the application against the respondent. 87. The applicant may, within 21 days after the day on which the affidavit is served, file an affidavit and serve a copy of the affidavit in reply on the respondent. Why is it 21 days? Well, it's 28 days in the early provisions, but this particular provision is made with reference to companies' disqualification of directorship provision. The Court of First Instance actually has dealt with similar cases, and they agree that 21 days is the reasonable time period. And 88, after an affidavit is filed under 87 or after the expiry of the 21-day period, the parties to the application must not file or serve any further documents except with the leave of the tribunal. And Rule 89, the registrar may transfer the application to be heard by a member or members of the tribunal if the registrar thinks fit. And in Rule 90, the tribunal may make a disqualification order whether or not the respondent appears at the hearing. And a disqualification order may, in the absence of the respondent, may be varied or set aside by the tribunal. And 91, the applicant may at any time withdraw the application filed.
If members don't have questions, we can proceed to Part 5, clause-by-clause scrutiny. Part 5 covers special provisions for follow-on actions. We did have some policy discussions. Rule 92 is about interpretation of Part 5, with some definitions there. Rule 93 was discussed before. We considered members' views and would propose changes to Rule 93 such that there will be flexibility for a follow-on action to be filed in Form 8. As for the actual draft, we'll consult your legal advisor. Rule 94, if a person would like to seek permission from the tribunal for follow-on actions, then these proceedings should be followed. We did have a brief discussion on this previously. Rule 95, the defendant must, within 28 days after the day on which the originating notice of claim is served, file a defense and serve a copy of the defense on the plaintiff. Then Rule 96. The plaintiff may, within 28 days after the defense is served, file a reply and serve a copy of the reply on the defendant. Well, after the reply is served, if any party still wants to submit further replies, can that be done? No. We have to move on to Rule 97. That is, the first round of serving of information is completed, and there will be a direction hearing. For competition cases, we must have strong methods of management, because sensitive commercial cases may be involved. Therefore, the leave of the judge is required for further submission of documents. The judge will have that power. Yes, this is about powers related to case management. For certain cases, proceedings may be required for special proceedings, and we need to give the judge flexibility. The complexity, nature, and sums of money involved may be huge. So we must give more flexibility to the judge. All right, legal advisor. Thank you, Chairman. Concerning Rule 97, we note that in bracket 1, there is this expression, case management summons. Chairman, I'd like the government to clarify under the High Court rules, any provisions on these case management summons, like Order 25. If such an order is applicable here, should this be spelled out clearly here? Members will recall that under High Court rules, certain orders may be applicable. So maybe you should spell out in clearer terms here about these case management summons. Well, Order 25 under the High Court rules is applicable. In Rule 25 here, we've already spelled out that Order 25 is effective, because Rule 25 applies to all proceedings, including Part 5 follow-on actions. Well, the legal advisor is saying that you should write this clearer in Rule 97. Well, we'll have to go back and consider this. This is a drafting issue because this is already in Rule 25. Is it necessary to repeat this in Rule 97? Well, you may not need a lot of cross-references. If members don't have questions, we can move on to Part 6. Yes, please continue. Part 6 is about proceedings transferred from CFI. These are special rules. Rule 98, interpretation of Part 6. Rule 99 stipulates that the registrar must, as soon as practicable after the receipt of the documents, give notice to the commission and set a date for hearing. Rule 100, on the date of transfer. And once the transfer is effected, documents and proceedings will be deemed to be effective on that day, and the tribunal will still have the power to give direction to execute any order. Now, all these will not be affected. Now we move on to the forms. Form 1, originating notice of application. Well, normally, as previous rules say, apart from follow-on actions, usually Form 1 will be used. Form 2, forms for inter-party summons. Form 3, application for leave to intervene in procedures. The Competition Commission will have to use this form as well. Form 4, application for summons to a witness. So if any witness is to be summoned, Form 4 should be used. And then Form 5, summons to witness to appear and to produce documents. If an application is received, Form 5 can be used to summons a witness and require that witness to appear in court or in the tribunal. Form 6, notice of appeal against decisions of Registrar of Competition Tribunal. An appeal can be lodged with the judge. And Form 6 has to be used to lodge an application. Then Form 7, notice of application for leave to review a reviewable determination. Form 7 must be used for such a notice. Finally, Form 8, originating notice of claim, an application for follow-on actions. Yes? So much for the Competition Tribunal Rules. This meeting will last till 10:30. Would you like to continue? If possible, we would like to continue. Do you need to take a break? I don't think so. But if members need so, I'll be pleased to follow. All right, then we move on to Annex B, Rules of the High Court, Amendment Number 2, Rules 2015. You have a marked up copy here. Yes, we'll use the marked up copy prepared by the legal advisor. There are two major objectives here. For the tribunal and the CFI, we would like to clarify certain procedural provisions. There is a mirror provision, and some provisions can reappear here for application for appeals and for appeal proceedings. They will be similar for appeals from CFI to the Court of Appeal. But all these have to be put in the High Court rules instead of the Competition Tribunal Rules. Maybe we should move on to clause by clause scrutiny. Should I use English or Chinese? I think Chinese. Then page 1. This is about Order 59. That is Rule 1 to be amended. This is about appeal details. Then we can move on to the next page. Legal advisor, sorry, for the English version, I'd like to take this opportunity to mention a technical drafting point. On the right, you say you would like to add in or Competition Tribunal. I think the word the should be added for the sake of consistency. Ms. Poon? If you look at the text in Rule 2 is appeal to the district court. The word the will also apply to Competition Tribunal. So whether or not we add in the word the here, the meaning will be the same. But in view of the point made by your legal advisor, we'll add in the word the here. All right, next page, page 2 of the marked up version. We propose to add a new rule, 2BA. That is, if the Competition Tribunal refuses an application for leave to appeal, then just like in the CFI, leave can be applied to the Court of Appeal. Legal advisor, on the left side, for the original 2(b), there is a bracket 5. And then for the new 2(b)(a), we don't have a corresponding bracket 5. Is it that after deliberation, they're of the view that bracket 5 will not be necessary? Thank you for your comment, legal advisor. We studied this very carefully and agree with the legal advisor that bracket 5 in 2(b) should be added to the new 2(b)(a). Thank you, legal advisor. Page 3 of the marked up version. That's about Order 59 to amend 2(c), where an application for leave to appeal is determined by a single justice of appeal. A party aggrieved by the determination may make a fresh application to the Court of Appeal, and more than one judge will sit to determine the fresh application. Next page, Rule 4. We propose to add in bracket 5 in relation to an appeal from the Competition Tribunal or the Registrar of the Tribunal. A notice of appeal must be served, and the provisions are similar to those for the CFI. Page 5, no amendment proposed, so we can move directly to page 6. Here we propose to add a new Order 78(a). That's about the transfer of proceedings from CFI to the Competition Tribunal. We just finished with Competition Tribunal Rules. The provisions here are similar. So if necessary, I can revisit the provisions. Good. Number 1, interpretation of transfer order. We just scrutinized that. We can move on to number 2. This is similar to Rule 47 that we just scrutinized. A transfer order may be made by the court either of its own motion or on application of a party. It's just the reverse. Bracket 2 is the same or similar as Rule 18. The application must be made by filing a summons setting out the scope of the proceedings to be transferred to the Competition Tribunal. Rule 3, similar, and Rule 4, similar to Rule 49 in relation to proceedings transferred from the court to the tribunal in relation to effects of the transfer. And then we propose to add in new Order 78(b), transfer of proceedings from the tribunal to CFI. This is similar to Rule 78 to 100 of the Tribunal Rules. Rule 1, about the definition of transfer order. Rule 2, similar to Rule 99 just now. The Registrar of the High Court must, as soon as practicable after the receipt of the documents sent in relation to a transfer order, give notice of the transfer as well as the hearing date. And for Rule 3, is similar to Rule 100 of the Tribunal Rules in relation to the date of hearing, proceedings, and so forth. We just want to avoid any disputes. So, we've completed this draft. Legal advisor, Mr. Chairman, considering the English version of Order 78(b), that is page 10, first the 4th line, the expression made in the tribunal is used, but usually made by the tribunal is used. So for the sake of consistency, should this be amended as well? Ms. Poon, thank you, legal advisor. We agree to this proposed amendment.
I think I do.
Please carry on. So let's go to NSC about the fees. Competition Tribunal fees rules. Okay, before the clause-by-clause scrutiny, let me tell you the purpose of NXC. Like other courts, the judiciary proposes listing out some fees rules so that users of the court service would know what they're expected to pay. Because the tribunal actually involves similar procedures, as other courts. So we propose that for the sake of convenience, for these fees rules, we will try to model them on the rules by the High Court, and the level will be similar to that charged by CFI. So now, clause by clause, commencement date, the rules will come into operation on a date to be appointed by the chief judge by notice published in the Gazette. So it will be effective after the main legislation comes into effect. Yeah. And then Section 2, interpretation. Section 3 on the rules payable in tribunal. Actually, there are Schedule 1 and Schedule 2 covering the fees. Let's look at Section 1 under Rule 3. It refers to Schedule 1. We use the referential approach. That is, we would not list the actual fee levels, but in Schedule 1, we only covers the fees charged for relevant items, so that we can actually try to reduce the complexity involved in making changes later on. And subsection 2 refers to Schedule 2, which lists out the fee levels for different items. So Schedule 1 and Schedule 2 actually would actually involve fees similar to what's charged by CFI now. And Section 4 stipulates that the registrar may reduce, remit, or defer payment of a fee payable. This is actually similar to the or the same as provision under the Rule 2, Proc.to for High Court. And Section 5 states that, a fee paid under these rules is evidenced by causing the relevant document to be franked with the amount of the fee. Now, we've come to Schedule 1. Do you want me to explain item by item? Actually, they're the same as that covered by the High Court. What do members think? If not, then, okay, if that's necessary, then we don't need you to go through it item by item then. So if members have no questions, members, let's go to NSD. It's about the status of legal advisor. Excuse me. On the fees, I think the administration can tell members, as Ms. Zhang said, there are two schedules here, 1 and 2, and Schedule 1 uses a referential approach. That is the fees and make reference to High Court, and Schedule 2 would list out the fees. Schedule 2 doesn't use the referential approach. So maybe the administration can explain further. Ms. Poon? Yes, thank you, legal advisor. I think in preparing these two schedules, we need to reflect the policies of the judiciary, and also we need to make sure that the schedules are easy to understand. So Schedule 1, as just explained, if there's an item, payable item, that is governed by the fee rule in the High Court, and Competition Tribunal has a similar item that requires payment, then we will link it to the High Court, which means using the referential approach, making reference to the fee rules for a specified item in the High Court. So that's the approach of Schedule 1. But under the competition ordinance and the subsidiary legislation, there are some separate fees or special fees charged that are not charged in the High Court. Therefore, we have the Schedule 2 here. For example, in Item 1, under commencement of proceedings, there are actually specific or specified fees charged. And these fees are not fees that actually requires the registrar to assess or relevant personnel to assess how much the level should be. For example, in Item 3 or Item 6, which involves which actually is charged under Section 93 or Section 109 of the ordinance, provisions that are unique to the competition law. Therefore, for these unique items, we list out their fees in Schedule 2. So that's the function of Schedule 2. Thank you.
如果可以
Okay. Okay, if possible, then we can move on to NSD about suitors funds rules. Before clause-by-clause scrutiny, let me tell you the purpose of the rules here. The suitors funds rules actually are here to actually make sure that there's money lodged into the court, and the result is that the funds may be actually used to fund, the relevant parties. Similar to the fees mentioned earlier, the tribunal will operate in a similar manner as the High Court. So in compiling these funds rules, it's like actually copying exactly the relevant rules, Section 4B for the High Court, for rules of High Court. But in another review, we did review all the rules covering suitors funds under the judiciary, and we've optimized some of the provisions, and therefore we've incorporated the optimization provisions, trying to improve the operation of the funds. But I will give you the detail later on when we come to the specific clause. So Section 1 is about commencement. That is, the rules will only come into operation when the law comes into effect. And secondly, interpretation, legal advisor. I think a technical issue here, we can see that in the English term, registrar actually uses a small letter R. But for other rules, normally the registrar uses a capital letter R. So maybe the administration can look into this. Mr. Chen? Yeah, we'll consider changing it, yes. Changing the capital letter. Okay. So Rule 3 stipulates that all funds has to be lodged in the tribunal, and there has to be a separate account for the funds. How about a capital letter for registrar? Yes. We will change the letters of the registrar. Yes. And Section 4 stipulates that receipt has to be issued. And Section 5, there is to be a keeping of accounts and register to keep appropriate ledger accounts to which all funds lodge the money or securities. And there also will be a need for annual statement of accounts. Securities, yes, 7. Rule 7. All kinds of securities may be lodged in the tribunal. It also covers how the securities would be placed. And also, Section 8, principal money and dividends in respect of or on securities to be placed in registrar's books. And Section 9 covers payment out of money lodged in tribunal. I want to highlight one point here. Section 3, subsection 3, this is provision that payment out in cash or by check must be made at the tribunal on weekdays except Saturdays and general holidays between 10 a.m. and 1 p.m. and between 2 p.m. and 4 p.m. As I mentioned earlier, as a result of our separate review, we found that the time slots here, mentioned here, is shorter than the opening hour of the accounts office. I think this is something due to history. Often people will use a lot of the computers, so if we can indeed actually make sure that the check writing period can be the same as that of the account office. So we can propose a change that we can just write that the time period be the same as the time when the account office is open. And for Section 10, it covers payment out to be ascertained by certificate of registrar. And 11, if an order directs payment out of the funds of any cause directed to be taxed, then what the registrar must do. That's what's covered here. And Section 12 covers payment out, transfer, etc. of funds to person representatives of person entitled to payment. Well, this is actually the same as what's covered by Rules of High Court. I'm not going into detail here. Section 13 covers order directing payment out, transfer, etc. of funds to describe persons entitled to payment, etc. 14 covers the order directing investment of money lodged in tribunal. So the procedures to be followed. 15 covers order directing other dealings with money lodged in tribunal. Withdrawal, lodgement, transfer, or investment, in order other than those areas, then procedure to be followed. 16 covers the carrying over of funds to a separate account. 17 states that the registrar may invest any money and vary the investment at any time. We have tried to optimize this provision as well. In the High Court, when will the interest be given to the plaintiffs is in 14 days. That's the situation before computer was not so common, and it took a lot of time, administrative time. But now with computerization, we can really shorten the time to 3 days. So I think, to be fair to will be fairer to the plaintiff or the litigants. Okay, and then 18, legal advisor. As Ms. Zhang just said, 17, subsection 4 is now, 14 days is now changed to 3 days. And Ms. Zhang said that in another judicial review exercise, the same change will be made. So can you explain to members, in response to the proposal for review for the High Court, when will that take place indeed? Okay, I think our review is coming to an end. Of course, we'll see. If members have no question about this provisions, then we'll incorporate the review and the amendments into 6 other, fund fees rules. And so hopefully before the summer, we can consult the relevant parties, and if possible, if there's approval, we will try to incorporate the changes to the other funds rules before the end of the year.
Another point is about 17 bracket 9 of the Chinese version. In English, it's business day. In Chinese, it's 工作日. I note that in the company's ordinance, that is Cap 622, Section 261, bracket 7, in the English version, the definition of business day is more or less the same as here. But in Chinese, it's 辦公日 in that ordinance, and working day is 工作日 in that ordinance. So bracket 9 may only be applicable to this particular rule. maybe the government can go back and can consider the issue of consistency between 工作日 and 辦公日. Will examine your legal advisor's comment. In the Chinese version, 工作日 or 辦公日 is all right, depending on the text. This is not a problem. In the Competition Tribunal, just now when we scrutinize the Competition Tribunal Rules and when we scrutinize the Competition Ordinance, this expression has not been a problem. So long as the meaning is clear, this shouldn't be a problem. Mr. Chung Kok Pan? Any restrictive items for investment? Ms. Cheung? Usually will adopt a conservative approach in terms of investment, usually in terms of time deposits. Recently, stock prices have been escalating. Well, we dare not do so. So you only place the money in savings account. Yes. And sometimes time deposits. And then Rule 19 stipulates that the cost of administering the various accounts required to be kept under these rules is to be defrayed out of the general revenue. This is similar to the High Court case. Rule 20. If a person is entitled under an order to receive dividends or other payments, and the person is still alive, then the evidence must be given by an affidavit. Rule 21, a statutory declaration or affidavit will be in order. This is to give more flexibility to the litigants. Rule 22, a certificate of amount and description of funds as well as other details have to be provided. Rule 23, if the judicial administrator receives a request, then a transcript of the account in the registrar's books must be provided. Rule 24, if any sum of monies remains unclaimed in the tribunal, then the Chief Justice may order that the sum be transferred to the general revenue. As for the remaining forms, they are identical with those under the High Court rules. Do I need to explain the details? No. Well, members and our legal advisor have raised certain questions. Maybe we should convene another meeting to handle those issues. Clerk? The next meeting will be on the 12th of May. Do we have an earlier date? Well, there may be filibustering in the LegCo meeting, so April may not be possible. How much time will you need to handle those issues? Mr. Chairman, apparently only drafting issues remain. They're rather technical. Maybe we can discuss in detail with your legal advisor to see how to improve the text. Maybe soonest by the end of April we'll be able to come up with an amended English and Chinese texts for the perusal of your legal advisor. So only technical issues remain, and maybe you can then decide whether or not to call another meeting. Mr. Wong Ting Kwang, Mr. Chairman, I believe the appropriation bill and the constitutional reform legislation will cost us more time in terms of scrutiny. So maybe we'll have very tight schedules of meetings in the coming months. So, Mr. Chairman, you should consider whether or not further meetings are necessary. If we're only on technical amendments, then maybe the government can work the details out with the legal advisor. Then we can save some time. Well, I think this comment is reasonable. You say by the end of April you'll be able to give us new texts. Then we'll see whether we need any more meetings. I think members' views are more or less the same on this point. So thank you very much. Thank you, Mr. Chairman.